Hollywood troublemaker, and your favorite voice of reason in a town built on delusion.
The tension in the courtroom was the kind you could almost touch, that strange static air before a summer storm when everyone knows something is about to break but no one dares to say it out loud. And in this particular moment, all eyes were fixed on the defense table where Blake Lively sat, composed in outward appearance yet radiating an undercurrent of controlled defiance, her shoulders squared, her hands flat against the polished wood, her gaze unblinking as if to project a silent message. That she was here on her terms and hers alone, but that carefully curated poise met its first disruption when the judge's gavel came down sharply, a sound so crisp it sliced through the hum of shuffling papers, muted coughs, and the faint buzz of the overhead lights, a single decisive strike that immediately halted the rhythm of the hearing and set in motion a ripple effect of stunned glances, halted pen strokes and sudden, almost synchronized silences from the cluster of reporters seated toward the back of the room, their fingers frozen above laptop keys as they registered the words that followed. The deposition, Blake Lively's deposition, the one many believed would contain the most revealing, perhaps career-altering testimony of the entire case, was to be sealed from public access effective immediately, an order delivered so swiftly it carried the unmistakable weight of premeditation, as though the decision had been quietly waiting in the wings, ready to step onto the stage. The moment the opportunity arose, and just like that, the most anticipated document in the room, the piece everyone had been whispering about in hallways and speculating over in late-night calls, vanished from the public record, its contents locked behind legal walls as impenetrable as the dark stone columns framing the courthouse entrance, leaving behind not answers but a vacuum into which speculation rushed like air into a sealed chamber, the kind of vacuum that in Hollywood law circles is both dangerous and intoxicating because when the paperwork disappears, the stories multiply. The courtroom itself was a study in deliberate contrast, half of it occupied by attorneys in tailored suits, their briefcases neatly aligned beside them, their expressions a mix of confidence and guarded calculation, while the other half brimmed with members of the press and a handful of strategically positioned spectators who had, by all appearances, secured their seats early for the sole purpose of catching something. A slip, a side comment, a facial twitch, that could hint at the truth. Hidden behind the legal choreography, and even among the sketch artists midway through their illustrations, pens paused mid-stroke when the judge's voice cut through, the decision delivered without preamble, without the kind of drawn-out procedural reasoning that often preludes such rulings, and that abruptness only intensified the questions that began swirling silently among those present. Why seal it now in this exact moment? And what precisely could be inside those pages so sensitive, so potentially explosive, that it justified immediate removal from public reach? The explanations available in that moment were scarce and unsatisfying. Perhaps it was a matter of personal safety, perhaps there was confidential evidence implicating unrelated third parties, or perhaps, as some skeptics muttered under their breath, it was simply the sort of privilege afforded to a figure whose face graced magazine covers and brand campaigns worldwide, a privilege that could bend the normal cadence of court procedure into something far more expedient. And while this wasn't the first time such a sealing order had occurred, there were precedents, cases where blockbuster leads had their entire sworn statements vanish into private archives overnight, or where pop stars' financial disclosures had been erased from filings in a matter of hours. The pace of this decision stood apart. It was immediate, leaving no gap for leaks, no window for a clerk's oversight to accidentally funnel the transcript into public hands. And that speed hinted at strategy. Legal insiders would later confirm that this was no spur-of-the-moment ruling but the culmination of a calculated approach by Blake's legal team, a move they had been constructing quietly for weeks, filing motions, laying groundwork, and shaping the narrative so that when they arrived in court that morning, they carried with them not only the legal basis for sealing but a story, one of irreparable harm, that rare legal phrase whose gravity tends to draw a judge's ear, a story that cast the public release of her testimony as a threat not just to her reputation but to ongoing business dealings, personal relationships, and a network of third parties who, they suggested, could be unfairly dragged into the glare of public attention should the transcript see daylight. This argument was not without its force. Irreparable harm is a heavy term in litigation, one that signals damage beyond repair, the kind that no post-trial victory can undo, and when paired with the assertion that much of the deposition's content was irrelevant to the actual claims at issue, it boxed the judge into a narrow lane. Protect the record now, or risk releasing information that might later be ruled inadmissible but would by then have already done its damage in the court of public opinion. The opposing side, however, did not concede this ground quietly, pushing instead for transparency, arguing that in a case already drenched in media attention, much of it, they pointed out, fueled by Blake's own public statements, the public had a right to hear all testimony, that the door to scrutiny had been opened by her own hand, and that sealing now would only deepen suspicions about the content. This clash, privacy versus accountability, is one of the oldest tensions in celebrity trials, but here it played out with unusual swiftness thanks to a procedural tool that few outside of high-stakes litigation ever encounter. The emergency request for confidentiality, filed just before the hearing began, effectively forcing the judge to decide on the spot before the deposition could be officially entered into the record. And by executing this maneuver with precise timing, Blake's lawyers ensured there was no liminal moment in which the material could slip into public access, intentionally or otherwise. Similar maneuvers had been used before in Hollywood. In one case, an Oscar winner's rehab testimony vanished after a last-minute filing. In another, financial records evaporated from the docket within hours. And in both, the sealing order became the headline, eclipsing the lawsuit itself, which in some ways was exactly what happened here. By the time the court adjourned, chatter in the gallery had shifted almost entirely from the substance of the case to the mystery of the missing transcript. Yet for all the neatness of the strategy, cracks in the narrative began to show as other filings emerged, some of which hinted that the deposition addressed key allegations directly, making the claim of irrelevance harder to swallow. This tension deepened when attorney Fritz, representing the opposing side, pointed out in his filings that Blake's characterization of her deposition as a rough draft was misleading. The document bore no such marking, meaning it was, for all intents and purposes, the finalized transcript of her sworn statements, and as such, a legitimate piece of evidence, not a provisional work product. Fritz framed her sealing effort not as a protective measure but as an attempt to strike documents from the record in a way that federal rules simply did not authorize. Rule 12, he argued, allows for striking pleadings, complaints, answers, counterclaims, but not exhibits attached to motions or oppositions, and to reinforce the point, he cited directly from cases presided over by Judge Lyman himself, an elegant rhetorical choice that subtly reminded the court of its own precedents. The implication was clear. This motion was built on shaky procedural ground, and in highlighting that, Fritz also turned attention to the irony that Blake's own filings had opened the door for his side to respond with the very deposition she now wanted hidden, since her earlier letter to the court had advanced arguments that invited rebuttal. In that rebuttal, the deposition was attached to demonstrate, as Fritz put it, that her claims of an ongoing smear campaign were unsubstantiated. It was, he argued, routine for courts to consider deposition testimony in discovery disputes, and to suggest otherwise was to misrepresent common practice. Moreover, Fritz addressed Blake's assertion that the Wayfair defendants had leaked details of her deposition to the media, calling out the absence of evidence. Not a single citation, not a shred of proof, and further noting that if such a leak had occurred, it could just as easily have originated from her own camp, which included her husband, multiple attorneys, law firm staff, and even the catering personnel present at the deposition, all of whom had equal access to the proceedings. This point was delivered with a kind of restrained bite, not accusing her directly but stripping away the certainty of her narrative by presenting alternative explanations that were both plausible and unflattering. Through it all, Fritz maintained a tone that was respectful yet unflinching, the sort of legal writing that doesn't need to raise its voice because the sharpness of the logic carries its own sting, and in doing so, he effectively reframed the sealing not as a neutral procedural act but as part of a broader pattern in which Blake was actively shaping, or spinning, the public story of the case, a story that, in his telling, did not align with the procedural reality. By the time the filings were public, the battle lines were sharper than ever. On one side, a celebrity fighting to keep her sworn words out of public circulation under the banner of privacy and protection from irreparable harm. On the other, a legal team pushing back against what they saw as narrative manipulation, calling for transparency and adherence to procedural rules. And somewhere between those poles sat the judge, now holding a sealed transcript whose contents had become the subject of more fascination than perhaps anything in the case itself, the mystery of its pages proving more potent than any leak, precisely because they were locked away, at least for now, behind the weight of a court order. The gavel's echo still lingering in the minds of those who had been in that room when the decision came down in an instant, reshaping the trial's trajectory in a way that only the most calculated legal moves can. The air inside the courtroom that morning was heavy with the kind of charged anticipation you don't often feel unless you're in a space where reputations can be dismantled in a matter of minutes and careers can shift course before lunch, the kind of air where every cough sounds louder, every shuffle of paper sharper, and every passing glance between attorneys is laced with strategy, calculation, and just a hint of concealed disdain. And at the very center of that atmosphere sat Blake Lively, a figure whose public image had been carefully built over years of Hollywood premieres, flawless magazine covers, and charitable photo ops. Yet in this moment she was stripped of the cinematic glow, positioned instead at the defense table under the flat, unforgiving light of the courtroom. Her posture straight and deliberate. Her hands splayed evenly on the polished wood as if to anchor herself against whatever might be coming. Her expression neutral but with eyes that hinted at a storm held firmly behind the gates. Across the aisle, the opposing counsel sat poised, their stacks of legal briefs meticulously arranged, the blue and white tabs sticking out like battle flags, and every so often one attorney would lean toward another, whisper something short and sharp, the kind of communication that carries an entire argument in a single breath. And then it happened. The judge, without the slow build-up that usually comes before a significant ruling, brought the gavel down with a decisive crack, a sound so sudden and so crisp that it seemed to slice through the ambient noise, through the low hum of the ventilation system, through the staccato typing of the reporters seated in the back row. And in the next breath, words followed that instantly shifted the room. Blake Lively's deposition, the one piece of testimony many expected would provide the most unfiltered glimpse into her role, her decisions, and her version of the events at the heart of the case, was to be sealed from public access, effective immediately. No preamble, no gradual build-up of legal reasoning, just an instant command that removed the single most anticipated document from public reach, and in that moment, you could see it happen. Sketch artists froze mid-line, reporters' fingers stilled above their keyboards, the faint mechanical clicks of camera shutters stopped mid-press, and even the rustle of coats and scarves from the gallery ceased as the words landed. The gallery itself was a calculated blend of legal professionals, journalists, and a scattering of strategically positioned spectators, the kind who weren't there by accident but because they knew that sometimes the biggest shifts in a trial come not from verdicts but from moments like this, where information is suddenly locked away. The courtroom was, in that instant, transformed into a theater of unanswered questions. Was the sealing about personal safety? Could it be related to sensitive third-party information? Or was it the subtler, quieter exercise of privilege that comes with being one of Hollywood's most photographed faces? A privilege that bends the rhythm of legal proceedings to an accelerated, less public pace. This wasn't the first time such a maneuver had played out in a high-profile case. There had been an Oscar winner whose testimony about a private rehab stay disappeared into sealed files within hours, a chart-topping musician whose financial disclosures were whisked off the docket after a last-minute filing, a blockbuster actor whose on-set behavior under oath was locked away overnight. But the speed here was noteworthy even in that context. There was no recess to review, no delay for procedural consideration, no drawn-out debate. The decision landed like a pre-rehearsed cue in a play where every actor already knew their line, which only added weight to what legal insiders later confirmed. This was no spur-of-the-moment choice, but the endgame of a strategy Blake's legal team had been quietly building for weeks. They hadn't walked into that courtroom hoping for an opportunity. They had walked in carrying the blueprint for this very outcome. Through motions filed with surgical precision and an unbroken narrative of irreparable harm. A phrase that, in legal terms, is as heavy as a lead anchor. They framed her testimony not as central evidence but as a potential grenade in her personal and professional life, one that, once detonated in public view, could not be diffused even with a courtroom victory. The idea was simple but potent. If the deposition were released, it could ripple far beyond the boundaries of the case itself, harming her ongoing business ventures, brand partnerships, and personal relationships, and, critically, dragging unrelated third parties into the media glare. This argument, especially in celebrity litigation, is often persuasive because it allows a judge to act not merely as an arbiter of legal disputes but as a protector of collateral damage, and when packaged with a procedural mechanism known to only the savviest litigators, an emergency request for confidentiality filed minutes before the hearing, it all but forced the court to decide before the transcript could enter the public record. The opposing side, led by attorney Fritz, was not about to let the moment pass unchallenged. They leaned into the counter-narrative of transparency, pointing out that Blake herself had repeatedly addressed related topics in public, effectively inviting scrutiny, and that in a case already steeped in media coverage, the public had a right to the full record, not a curated version. Fritz's written response carried that same blend of professionalism and pointed dismantling of the other side's framing that seasoned trial watchers appreciate, respectful in tone, but with a sharpened edge. He called out Blake's claim that her deposition was a rough draft, noting that it bore no such marking and was, by every procedural measure, a finalized, accurate transcript of her sworn statements. He dismantled the procedural foundation of her motion, pointing out that Federal Rule of Civil Procedure 12 allows a court to strike pleadings, complaints, answers, counterclaims, but not exhibits or attachments, and in a tactical flourish, he cited directly from prior rulings by Judge Lyman himself, effectively reminding the bench of its own established reasoning. This wasn't just about the letter of the law. It was a subtle way of anchoring the argument in the judge's own judicial DNA. Fritz also reframed the narrative by pointing out that Blake's own prior letter to the court had made arguments that invited rebuttal, and that rebuttal had included the very deposition she now wanted hidden, attached to demonstrate that her allegations of an ongoing smear campaign were, in his words, unsubstantiated. It was, he argued, routine for courts to consider deposition testimony in resolving discovery disputes, and to suggest otherwise was, at best, a mischaracterization of common practice. Perhaps most surgically, Fritz addressed Blake's accusation that the Wayfair defendants had leaked details of her deposition to the media, noting not only that she cited no evidence whatsoever but also that if a leak had occurred, it could just as easily have originated from within her own circle. Her husband, her attorneys, law firm staff, even the catering team she had insisted host the deposition, all of whom had equal access to the content. This line of argument didn't have to accuse her outright. It only had to inject enough doubt into her narrative to weaken, and yet, despite this robust counterattack, the day ended with Blake's side securing what many legal observers called a procedural win with PR consequences, because in high-profile cases, a sealing order can sometimes become a bigger story than the testimony itself. The very absence of the deposition from the public record transformed it into a kind of forbidden text, one whose contents could be imagined, speculated on, exaggerated, but not confirmed, and in that vacuum narratives thrive. Inside Hollywood's interconnected ecosystem of legal strategy and media spin, this moment would be dissected in private conversations over industry lunches and in hushed tones on studio lots. Had the deposition been sealed to protect genuinely irrelevant personal details, or had it been sealed because, as some suspected, its contents could detonate the carefully managed public persona Blake had cultivated over more than a decade? That question, unanswered and perhaps unanswerable in the short term, became the quiet hum beneath the official proceedings, and for those in the gallery that morning, the memory of the gavel's echo, the frozen sketch pens, the halted camera shutters, and Blake Lively's unblinking gaze in the seconds after the ruling would linger as a reminder of how, in the strange theater of celebrity trials, sometimes the most powerful statement is the one that never makes it into the record at all. Thanks for watching. Subscribe my channel.